want to talk about holdovers. So if you're facing an eviction or illegal sublet, non-primary residence, owner occupancy, profiteering, licensee proceedings, chronic rent delinquency, nuisance, or any other grounds besides rent, then you're going to want to listen very closely. Now, holdovers are different from non-payment proceedings because, in most cases, you must retain an attorney if you have a chance of mounting a successful defense. Yeah, there are some success stories, where a tenant represented herself in a complex holdover and won, but that is the exception more than the rule. Honestly, defending a holdover would be a tough job, even for an inexperienced attorney. If you followed my directions on researching a landlord, which I presented in the first part of this video, you are already providing your attorney with the needed background, saving yourself money in the process. And this video could save you even more money because I'm going to spend the time now to give you the basic information that you would otherwise have to pay an attorney to give you in person. If the landlord starts a case about, whatever, illegal subletting, non-primary residence, pets, chronic rent delinquency, or owner occupancy, the bottom line probably has nothing to do with any of those things. The bottom line is that the landlord stands to make a greater profit by evicting the rent-stabilized tenant, renovating the apartment, getting it off rent stabilization, and renting it to a free market tenant. Now, how does the landlord accomplish this? Well, there are several methods. If I worked for landlords, I could write a book on the myriad ways to get an apartment off of rent stabilization. But the point is that if you are a rent-regulated tenant and you ask some of your newer neighbors what are they paying to live in your building, it's easy to calculate how much the landlord could be making if you moved elsewhere. Multiply that profit over a span of 2 or 3 or 4 years, and then you can see that the landlord stands to make tens of thousands of dollars. Now, what if the landlord is preparing your building for sale? Now we're talking about potentially hundreds of thousands of dollars. So if the landlord is motivated by profit, then what motivates you? Well, the same thing, money. Have you looked for an apartment lately? Are you aware of how much the rents are? Just by living in your rent-regulated apartment, you are saving at least $500 per month, and that is an invaluable asset. Do you have any other assets that are that valuable? In order to make $500 a month in dividends, you would need $150,000 worth of stock in Citigroup. So your landlord is highly motivated to get your apartment. You are highly motivated to protect your apartment. That means that both sides are going to spend substantial time, money, and resources and throw them into the fight. There are at least 10 different types of holdovers, and for each type, landlord has a unique set of weapons available, and the tenant has a unique set of weapons available. Experienced lawyers see the same patterns day in and day out. Familiar patterns like this. The landlord says they're subletting, tenant says that the subletter is a relative. The relative wants succession rights, landlord says the relative hasn't lived there long enough to get succession rights, and it goes on and on. And so each case is unique, and each case is the same. In many holdovers, the law gives you an opportunity to cure. That is, an opportunity to avoid eviction by stopping whatever it is that the landlord says that you are doing wrong. In those cases, the first paper you get in a holdover is called a notice to cure. The notice to cure gives you the time frame that you have to cure the violation. The law requires that the landlord give you an opportunity to cure in some holdovers, but not in others. So that means 3 things. First, if you get a notice to cure and you're doing something wrong, then you could consider stopping whatever it is that you are doing within the time frame in the notice. That could prevent your eviction. Second, there are serious legal consequences to the landlord if he fails to send you a notice to cure when he should. In one of my cases, where I litigated it for more than 1.5 years, the landlord lost at the end, right on the last day of trial, because the judge ruled that way back in the beginning of the case, the landlord should have served that notice to cure. Third, the notice to cure forces the landlord to have to prove at trial that he violated the lease both before and after the notice to cure was served. So take, for example, if the landlord is accusing you of refusing access to the super so that the super can do repairs. The landlord sends out a notice to cure. At trial, he has to prove that the tenant refused access twice, both before the notice to cure and after the notice to cure. If your landlord is claiming that you don't live in your apartment, you are facing a non-primary residence holdover. The notice you will receive is called the Notice of Non-Renewal, also known as a Golub notice. 3 tips to fighting non-primary residence holdovers. First, the most important feature of a non-primary residence case is documents. Documents are almost everything. Your tax records, educational records, insurance, employment records, bills, bank and credit card statements tell a full story of where you live and where you spend most of your time. Collecting these documents early, organizing them, and reviewing them are paramount. Separate these documents by category and place them in backwards chronological order, and produce them for your attorney as soon as possible so that he or she can map out the chronology of your presence in your apartment. Second, you should understand that the landlord can only serve the Golub notice in a window of 90 to 150 days before the lease expires. So if you have a technical grounds for dismissing the case, like improper service, then it becomes ever more significant. If the landlord's case is dismissed, he can't quickly bring the case again. In most circumstances, he has to allow you to renew your lease and then wait another 2 years before serving another 90-day notice. Third tip is that even if you spend significant amounts of time away from home, it may not matter because it's important to know why you are away from home. For example, you could be away for business purposes. You may also be away for school. You could also be away for any other temporary reasons which do not amount to a permanent abandonment of your residence. There are 100 different permutations of this type of case. I represented a tenant in a jury trial over non-primary residence, and in there he testified to the jury that he rented an apartment and had his primary residence there despite the fact that he owned a building right next door. So every non-primary residence case has its own story. A lot of times, it's a question of how skillfully it is presented. A tenant generally cannot sublet a rent-stabilized apartment to someone unless she gets the landlord's written permission first. When the landlord thinks that the tenant has sublet the apartment illegally, he commences the next type of holdover we will cover, the illegal sublet holdover. The notice you will receive for the illegal sublet holdover is called a notice to cure. The illegal sublet holdover is a close cousin of the non-primary residence holdover that we discussed previously. In an illegal sublet holdover, the landlord has approved 2 things. 1, that you do not live in your apartment, and 2, that someone else does.